Everyone's talking about the world's first regulated AI law firm, but I wanted to go deeper. So I've created an exclusive podcast series that goes beyond the buzz. Over the next few episodes, I'll be sitting down with the CEO, Philip Young of Garfield Law. We've put together the most pressing questions from professionals across the legal industry, and we're addressing them in this series. In this episode, we dig into the tension between regulation and innovation. When does it protect us and when does it hold us back? And more importantly, what does good regulation actually look like in a world driven by AI?
One of the takeaways I've taken from this chat with you, Holly, is that I need to go and get a haircut pretty urgently.
I'm going to ask you a serious question now.
Regardless of AI laws, when it was written, no one ever contemplated that there might ever be legal services provided by AI.
Everything's going wrong and it's like Frankenstein. You've invented this thing and it's just going crazy.
Yeah, I'd like to get away from the word Frankenstein though.
That's hilarious. So, Philip, I'm really, really excited to have you back for round 2 because I feel like round 1, everybody was asking me questions and wanted to know more information, and I feel like we can clarify those points in this episode.
And so I suppose I say me again, and I hope your viewers are not horrified by that.
So the UK is not governed by the EU AI Act. We don't actually have an AI type regulation, which is interesting. Do you think that's a competitive advantage for legal tech companies in terms of innovation, or do you think it's more of a risk?
I think it's a very good thing that we're not governed by the EU AI Act. I think that it's a very ill-considered example of regulation, and I would be surprised if even the EU tries to maintain it for too long, because this is a world where if you're an advanced economy, you've got to be enabling your economy to be able to use AI and to build new products and to compete, because we're a global marketplace. And I think, unfortunately, I think the EU rushed into that far too quickly and without enough thought. And I'm just reading the news. I've already read lots of sort of commentary by people in Brussels saying, actually, this is a really bad idea. And in the end, it's either going to get partially revoked or it's going to be watered down or something will have to happen to it. In the meantime, of course, it's great that we're not subject to it. We don't have to comply with it. And therefore, if you're not building something that you're going to sell into Europe, you've got a lot more sort of regulatory space to innovate. Although our government is itself considering what legislation to pass and what regulations to pass, I tend to think with these things, I think it should be approached cautiously. In other words, we've already got excellent regulatory frameworks in lots and lots of different areas. And I think, in a sense, Garfield shows that for law, that the existing regulatory framework was flexible enough to enable some innovation, hopefully good innovation, I hope it's good innovation, but whilst at the same time provide all the safeguards that you would still want to see. Now, if you can achieve that with what you've got already, there's no point trying to pass more legislation, because all you're going to do is you're going to make things more complicated and difficult. And given that the current government's mission is growth, the last thing you want if you're going to try and encourage growth is to make it harder for businesses to create new products and new services. So I'm very glad that we're not in the EU's act's purview. I think it was ill-considered, and I think I'm already seeing sort of remorse from the EU about it, and I think eventually they'll just change it, frankly. Either that or they will continue to go down the path that there's that big report, I've forgotten who wrote it, very, very big name in EU circles, he published it in the last 6 months, where he said that the problem with the EU's market is it's becoming moribund, and that's a big problem. You need your market to be able to compete with America and the Far East and places like that.
Yeah, you're right. I think, there's so many legal tech companies in the EU, so many emerging markets. I was speaking to people from Poland and they were telling me, oh, now's the time for legal tech in Poland. And I'm like, oh, right. This EU AI Act, it does, I guess, stifle, if that's the right word, innovation a little bit. And we do have a competitive advantage, I think, and the US does as well. Let's say you're a law firm and you're looking to use a software, a legal tech software, and you're comparing something in the EU and something here, if we're looking at these two things, a legal tech solution in the EU, and then let's say you, like you're, Garfield, what's the difference? Like, is there something holding the legal tech providers in the EU back that law firms might need? What are the constraints?
I don't really know the answer to that because I'm not really very familiar with different jurisdictions in Europe and what their regulations are, and also at an overall EU level, I'm not really into the granular details, so I'm not needed to be. I think even before you get to law, tech, and things like AI and AI regulation, you might even find there's problems or challenges with the existing legal regulation. So I read on the internet after Garfield got into the news, some Dutch lawyers saying this would not be possible in Holland, regardless of AI laws. They said our legal regulation is written such that it presupposes that all services will be provided by humans. It's just been because when it was written, no one ever contemplated that there might ever be legal services provided by AI. So they just wrote it as though implicitly as though it's being provided by humans. So they said you couldn't have a Garfield in Holland without making significant alterations to our legal regulatory framework. So, I mean, that's almost sort of the first thing that you have to address in some jurisdictions, I suspect, even before you get on to interesting questions of AI and AI regulation. But beyond that, I'm afraid there's not much I can say, Holly. That's not something I've really focused on.
Yeah, no, it makes sense. I think that's so interesting that the law doesn't even allow in the first place for it to be provided by a non-human being. How interesting is that? I've wasted hours drafting contracts in my business. I've used clunky templates, even written from scratch, looked into paying lawyers. I've even tried ChatGPT, but it just didn't hit the mark. I knew there had to be a better way. And then I found this, Air Counsel, an AI contract drafter built by lawyers for lawyers. I spoke to the team at Air Counsel and they use it for their own legal work. And they're improving it every single day based on real life feedback. It actually does the heavy lifting for you. It researches your jurisdiction's laws and nuances and picks up local drafting quirks and even matches your tone and style. It then builds a ready-to-edit Word document with hyperlinks, numbering, and a table of contents. It's so quick. I was so impressed when I used it. What I love about it is you can ask it to draft any contract you like, and it will even give you suggestions for appropriate terms or clauses that you'd never even think of. If you're still spending hours drafting contracts the old way, you don't have to anymore. This changed everything for me. If you're a lawyer, business owner, service provider, it might just do the same for you. And Air Counsel have been kind enough to sponsor this episode, and I'm so excited to spread the word. It's the most sophisticated contract drafting software I've used. To get your free 7-day trial, just go to the description of this episode. Give it a go, and don't forget to let me know how it changes your workflow.
It's not surprising, but I mean, it's almost surprising the other way around that our regulatory framework in England doesn't have that sort of baked in. It's been written in very neutral terms. Well done if anyone's listening to this and they wrote the SRA's latest series of rules. It'd be a committee of people, won't it?
I actually can't even believe that because, when you look at these ridiculous, I'm going to say, laws on property laws, and weird things that are in like covenants and just weird like land laws. And then we don't have this term that they have in Holland. That just baffles me, knowing the law.
Yeah, I know, isn't it? I mean, it's mad. I mean, years ago I looked at the deeds to my house, and the things that the Edwardians decided to restrict my predecessors from doing are very random. It's like on my property, you can't conduct a brick kiln operation, so you can't sort of mass produce bricks. God knows why you want to mass produce bricks where I live. And there were sort of random other things, including immoral activities and stuff. And I was like, okay, well, I sort of understand that, but it's just like someone sat down and thought a whole series of very random, unconnected things should be banned, which is very odd. You think there'd be an overarching theme to it, but there wasn't.
I remember seeing one about, you're not allowed to just keep pet pigeons like that. I mean, it makes total sense, but how on earth did you come up with that one?
I think that tells us that whoever wrote that covenant in had been afflicted with a neighbour who had pigeons at some point.
Yeah.
I can sort of understand that because my paternal grandfather did, after the war, he kept pigeons and he used to race them. He used to go all over the country and let them out, and they would fly home again, which is an amazing thing. But they didn't half coo. I mean, I'm not, I'm very neutral on pigeons, but whenever I was a young boy out in the garden at my grandparents and all the cooing, I could totally get why the neighbour was like, I'm banning pigeons now in all the covenants.
Maybe it was you who wrote that covenant.
I deny it, but I probably would write it though. Yeah.
I think you'd come up with some random stuff. Like no one else called Philip Young can live in this property in the future.
But interestingly on that, and this is very random, on LinkedIn, there's quite a lot of people in the world called Philip Young, it transpires, and a lot of them connected to me. So I seem to have an unusual subgroup of other Philip Youngs all over the world, and actually a disproportionate number of them are lawyers, which is really weird. I don't know what that's about.
You should create like a community of Philip Youngs.
Yeah.
The Society of Philip Youngs.
That's when I'm totally, by accident, sort of justifying the suggestion I'm a mad professor, which I'm really not. One of the takeaways I've taken from this chat with you, Holly, is that I need to go and get a haircut pretty urgently. So according to you, I've got crazy hair.
That's hilarious. Okay, I'm gonna ask you a serious question now. So if the SRA called you tomorrow and said, right, we need you to draft a guidance on AI, the use of AI in law firms, what would be the first thing you'd write?
Ooh, first of all, I'd cry a bit because that would be more work. But once I got past that, I think the very first thing you write about is responsibility and who's responsible. And you remind people, and including lawyers, of course, that you've got to use the right tool for the right job. You've got to be responsible for the outputs in some appropriate measure. You can't just sort of use this sort of technology without careful thought. I think that's the beginning of it. And when we look at some of the things that have gone wrong so far, so for example, the recent cases where lawyers have put hallucinated cases into submissions to the court, and there's one in America recently where a judge included hallucinated cases in his or her judgment. I think you've got to remind people that they've got to take care. That all of that's human error there. That's not understanding the tool that was being used, not understanding its limitations, and not checking things, and using an unregulated product for regulated services. So that's where I would start. And probably there'd be quite a long section about responsibility and being careful and using the right tool for the job. If you're at the SRA and you're thinking, now might be the time to get one of the Philip Youngs on LinkedIn to write. Please, I'm rather busy at the moment. Happy to consult, but yeah, there's a limit to what I can do. There's not that many hours in the day at the moment for me.
Oh dear.
I think there's a separate topic, which is we talked a bit about this earlier, when you're approaching the SRA, you want to think about these things because it's going to be the first thing the SRA is thinking about. And you also want to think about your product and what you're trying to do. And are you trying to do things that will make the SRA instinctively uncomfortable? So, for example, we don't have a client bank account. No money goes through our hands. And that's because I don't even want to think about the challenges of having a client bank account controlled by AI. I'm sure it's doable. It's just that just has risk written all over it for me, and not something therefore I wanted to go anywhere near. So just like that, think about your product and what risks it creates and how you mitigate them and all that sort of thing.
I think it's so good that you're the pioneer for this, for the revolution, for the future of law. But it also worries me that there's going to be other people who are wanting to do the same thing as you, but they won't be as responsible, ethical, or careful, because for me, it's very clear that you think about almost everything. Well, you try to at least think about everything and make sure that you're being very, very, very careful with what you're doing. But I do get a little bit concerned that someone not like you will come in and try to create something and want to scale it, and just it will just go out of hand. This is a concern, I think.
Yeah, I can't do much about that because that wouldn't be me.
It'll be another Philip Young.
Oh God, I don't want that. Everyone will then think it is me. I'd have to change my name. I'll change my name to Holly Cope.
That's fine by me. That's absolutely fine. Well, make sure you speak to all the Philip Youngs you've connected with and just tell them not to do that.
Yeah, I think that would be even more random, wouldn't it?
They'll think you've gone completely crazy then, I think.
Some of this conversation has been very amusingly random, hasn't it?
Yes. Yeah, absolutely, yeah.
So if you look at something like Garfield's a very integrated product because it integrates with the court system. Since we last chatted, we've integrated it with our users' accounts packages, so we can integrate to Xero, Sage, QuickBooks, Fresh Agent. There's integrations with Companies House. There'll be further integrations that we build in due course. And I think that's very much sort of the future of law tech products. They're not just be a standalone product. They're going to have lots of connections to other products and government services. In order to do that, we need government services to actually build the portals to integrate with. And that's a really important topic. I know that the legal aid agency is looking at this from their perspective, and I think we'll see more government agencies sort of building out their APIs and things to enable more functionality to pass with law tech products. And so I think law firms will be looking at this as well, because if they're building products internally, they'll be thinking about integrations, and obviously external providers like myself are doing this already. The challenge really with the government is finding the right people to talk to sort of point them in the right direction, and then persuade them of why it's necessary and the economics that would support it. That's my little crusade I'm on at the moment. And the senior judiciary have already been sort of beating this drum, so I don't think I'm sort of speaking out of school in saying that there's quite a lot of interest in this, and there's quite a lot of movement to try and sort of develop these sort of portals into existing government services.
What is it that you would want to see from government? If you could speak to them, what would you say and what would you ask for?
So what I've been asking for at the moment, and I keep asking for, and I ask for nicely with a big smile on my face, is a proper fully featured API for the court system. At the moment, there's a sort of partial API for bulk debt issuance in Northampton, but that's it. And what we really need, I think, as a country, is to have an API that accesses the entirety of the court process, not just for debt claims, but for other types of claims. And even the one for debt claims won't deal with the defended case. It only deals with issuing claim forms, default judgments, and admissions. We really need programmatic access to the entirety of a court process. And then what we're going to be able to do is move away from a lot of things that really annoy us as lawyers. So a lot of lawyers, when they're in practice, they have to communicate with the court by email, and then they've got problems sending big PDF attachments if they're court bundles, and the court rejects them and says, could you use a particular service? And if they're not signed up to that service, they can't use it. And that's all crackers. There should be, we're in the 21st century now, it's post-COVID, we should be able to transfer data instantaneously, seamlessly, and without all this pain going on. And then once you've got a court service API where you can transfer data with the court, you file your bundles instantaneously, very easily. You get data back showing that it's been filed, it's gone in front of the judge, all that sort of stuff. Law firms, once they've built it so they can talk to the court, they'll have a portal they can talk to each other with as well. So we're going to move away from service of documents by inadequate methods like email. And we could end up with service of document by data room or by online portal. And that also means that, when you're doing a big case, you've got multiple defendants, you can sort of segregate it by defendant, you can make sure which party has to receive what, all that sort of stuff. So I think that's the future, and that's where we need to get to. I just find at the moment it's crackers that even the court service is not set up to respond timely to things. And if you're in the High Court, it's much better. But if anyone who's listening to this is in the County Court, they will be able to tell more tales of woe than I can tell. And some of the stuff is mad. It's like when the County Court, the system is so broken that they generate the order, the sealed order, after the times for performance of some of the orders within it. So if you're a litigant in person, you've broken the order without knowing it, because you haven't even got the order in time. You might be ordered to disclose documents within 2 weeks. You get the order 4 weeks later. You've got no idea what you should have done 2 weeks ago. It's madness. All of that stuff needs to be fixed, and it's basically a technological problem. It can be fixed with a technological solution. So this is my big crusade at the moment. It's to persuade the powers that be that this all needs to be built. It needs to happen quickly, and we need to sort of try and make everyone's lives easier. Lawyers, litigants in person, judges, court staff, you name it.
Wow, that's a big job though, that.
Yeah, and we all know the government is brilliant at doing big IT projects. I mean, they're just renowned for the sensational way that they're delivered on time and within budget, and they have all the functionality. Cheeky comments aside, I think the way to do this, though, is to do it piecemeal. I mean, this is like completely self-serving, but there is already the OCMC that handles debt claims, and it doesn't have an API. Just build an API for that. They've already got a web-based portal. It can't be too difficult to build an API for it. Build that first. That sorts out debt claims. Scale it to the High Court. And then once you've got that technology, then find the next biggest area of usage in the county court and build the same product for that. And then move on. Talking to the Singaporean judiciary since our last chat, that's exactly what they're trying to do. And obviously they've got a good budget for this sort of stuff, and they've already got APIs and things. So they're ahead of us, as is often the case with Singapore. But we need to sort of, I think, as a country, catch up. But particularly as we've got an economic incentive to do so, because if you look, for example, my old stamping ground of the commercial court in London generates billions every year in invisible earnings for the country, which in turn generates tax, which in turn pays for public services. And one of the reasons the commercial court does that is because English litigation is very competitive. Now, if we become uncompetitive against our peer jurisdictions, then the work will go elsewhere. And in my career, I've seen a lot of arbitration work leave London just because London was seen as being uncompetitive compared to other places like Stockholm and Singapore, places like that. We've always got to try and innovate and try and stay ahead of the curve and try and keep England as a favourable jurisdiction.
What do you mean by uncompetitive?
If we become too expensive to resolve disputes, people will go to a jurisdiction that is quicker and cheaper.
Got you.
I mean, you need the infrastructure there as well, and you need, the judiciary being recognised as being entirely neutral and not in any way biased. Those sorts of factors as well, which are very strong factors in favour of England. But you still need fundamentally to provide a service to business people that they want to put English jurisdiction clauses into their contracts and resolve their disputes here.
Interesting. Do you know a country that is actually doing what you're talking about in terms of using technology to pretty much, I would say, systemize the court process and the litigation process is Brazil?
Yeah, I can believe it. Yeah. They're very forward-thinking in Brazil as well. But this just demonstrates that that this is for the sort of cases we're talking about here, which is sort of larger scale business disputes, it's an international market. We're a player in the market, and we need to try and maintain our very advantageous position, and we only do that by innovating.
Such an interesting point. Man, we could go into so many different interesting topics. We could talk all day.
We probably could. I don't know if your listeners have got all day, though.
In the next episode, we go into at what point should the law step in on AI? If you're a legal tech founder still trying to grow your brand, the reality is this: someone with half your expertise is about to outposition you. And when they do, you don't just lose reach, you lose deals, investors, opportunities, and more. I'm opening exclusive free access to a blueprint I've never shared publicly. If you want to become law firm's go-to legal tech solution, you'll need to become the leading authority. I explain exactly how in my blueprint. Go to the description of this episode to get it sent straight to your inbox now.